Welcome to It's No Secret, a podcast for those who want their money questions answered.
Join us as we talk to real Kiwis and share truths about our own financial lives, because the truth is, there is no secret to achieving financial freedom.
Lovely listeners, welcome back to another episode of It's No Secret. Today we are chatting about a juicy topic: what happens to my investments when I die? Bit grim, but Kat, take us away. Set the stage
I
here.
was like, wow, this is a positive intro. And then she's like, I'll just throw in a bit grim.
And then I'll be like, Kat, help me.
Yeah. Okay. So I think this is important for us to talk about.
Yeah.
We're going to try and keep it high level because there's tons of detail that we could go into. And I think we'll probably end up maybe doing a slightly longer version of this episode to expand into a few things. But let's just talk about the fact that probably most of our listeners are fairly young, so they're not really thinking about this. But it's important to also understand that if you have older people around you, whether that be your grandparents or your parents, having the uncomfortable conversation with them around making sure they have a will and that their wishes are legally and appropriately noted down is important, because we've had a few experiences at Kernel recently where we have been dealing with the beneficiaries of a deceased person's assets, and it's been really, really challenging for them to set those assets up in a structure in accordance to a will in some instances, which is also an interesting chat, but also when perhaps there's no will, right?
Yeah.
So the TLDR of this episode is like, get a will, talk to a lawyer.
Yeah, nice.
But we're also obviously going to talk about, what happens to your investments when you pass away. So scenarios, starting point. Should we start with a single person?
Yes. Yeah.
An individual account, I should say.
Yeah.
Yeah.
You could use me as an example because
Okay,
I don't have a will and I have an individual account and I don't share money with Ollie. So
Yeah, perfect. Okay.
like worst case scenario.
So we're obviously talking about an investment account specifically. So Christine does have an investment account with Kernel, and it's in her individual name. So any assets that are in your individual name when you pass away will be dealt with in accordance with your will. And if you don't have a will, they will be dealt with in accordance by the law, right? So what that basically means is that there's a process that has to go through the court so that it can be determined how any assets that you own can be distributed. And there's really a fairly simple-ish checklist that basically runs through your family circumstance. So how the assets or your investment account would be dispersed would be entirely determined by your family circumstance. So for you, Christine, I'm going to find the circumstance of, you do currently have living parents, but let's assume in this instance you don't.
Okay.
And you and Ollie don't. Well, actually you do. So should we maybe go to that one? Okay. So there's a spouse or a partner and parents, but no children.
Yeah, that's me.
Yeah. So you guys would be basically classified as de facto. So Ollie would be your partner.
Yeah.
So Ollie receives the personal effects such as your furniture, paintings, homewares, if you have them, clothes.
Okay.
$155,000 if your estate is that large, with interest from the date of death, and 2/3 of anything that's left beyond $155,000. Your parents would then receive the remaining third equally divided between them.
Interesting.
Yeah.
It's definitely not what I expected.
Yeah, or probably what you would necessarily want, because
no.
I'm assuming you don't anticipate needing your parents to receive money from your estate.
No, I'd probably give it to Annie.
Yeah, I was like,
Yeah,
you
my
have a
niece.
niece now, right?
Yeah,
You have a
yeah,
niece. But interestingly, like she's got no look in.
No, yeah.
Right?
Yeah.
Under the law in that instance, right? In the scenario, because I think this is also interesting, let's play out a scenario where you guys are a few years down the track and you have kids, whether you're married or not. If there's a spouse or a partner and children, it's not dissimilar. Ollie would receive all your personal effects. He'd receive $155,000 with interest from date of death and 1/3 of anything left. The remaining 2/3 of your estate would then be equally divided between children.
Right.
Or if there's one child, given to the one child.
Interesting.
Yeah. So it is, for whatever reason, I'm not a lawyer, so I don't know the details of it. I don't know where the $155,000 came from.
Yeah, it
as
seems
obviously a
random.
defined appropriate amount. But as you can probably appreciate in this, the thing that becomes a little bit challenging is like, how do you factor in property? Let's just assume you have tons of money in your investment account, because we're talking about investment accounts.
Yeah.
And the balance of your investment account is over $155,000. What would actually just happen in reality is that whoever is administering your estate, whether that be a lawyer or your executor, if you do have a will, they would reach out to us and basically say, hey, here's like proof of passing. We need to get a few legal documents from them. We essentially like sell down the account and disperse the money to a trust account, usually held by a lawyer, and then therefore like they're dispersing the money to those appropriate parties, either in accordance with the will or per
the law.
Yep.
So if you have a will, like if we were to replay those two scenarios with me.
What's in your will? Is it 100% to Annie? Sorry, Ollie.
No.
Okay. But your investment account, maybe your investment account
Yeah. Well, because also I guess it's tricky, and maybe this is good for chat, that my private equity shares are fully in my name, but it's like Ollie's contributed to that. So
that would need to be dealt with in a will, because otherwise that would be treated solely as your asset, and if you didn't have a will, would be distributed accordingly, which could then mean that depending on the scenario, if you guys have kids, the kids could receive more of that than Ollie could, or if your parents are still alive, your parents could receive some rather than it all going to Ollie. And then also where you potentially want to make a specific gift or amount to, say, a niece, that's not even covered unless you have a will.
Yeah, right. Yeah.
Now, naturally, you can kind of say this is how people end up in court, right? Yeah. Because I'm assuming that even if Ollie has the best intentions, if he's contributed to, say, the private equity that's currently owned in your name, in a similar way that like all of our private equity for Luke and I has come from joint money, but it's solely owned in my name. Would he fight it if it all went to Lily? Maybe, if he actually needed that money to live on. You know, even if there's like best intentions there. And so that's where like people basically get into going back to the court and trying to put forward other scenarios or reach agreements within the family, right? Because let's say the court determined that your parents did get some money, presumably like them and Ollie can reach their own private agreement. Whether or not that happens, not your problem, because you ain't here. But also,
fight
it's
amongst
like,
yourselves.
You never really know how that plays out.
I was just thinking about a scenario where, let's say, a grandparent passes away, and then they have written into the will that the grandchild gets the money, but then let's say the parent doesn't have enough money to live on, but then the kid is not over 18. Do you know what I mean? Like it can just get so complicated, because then the parent's like, well, I kind of need that money to like be able to support you. You know, but that's, I guess.
My general understanding of like, if it's noted like that in the will, then it can be harder for someone to go against.
Right.
You know what I mean? But there are some avenues of recourse under the law where if people feel like they've almost been excluded from a will, rightly or wrongly, then they do have some recourse after that person's passing to try and make a claim on that money. That's obviously just going to delay the whole thing. But it's interesting that you mentioned the grandparents with the grandchildren, because that's a scenario that we've been dealing with recently, where a very well-intentioned grandparent had left a specific sum of money to two grandchildren, and the executor of the will was the grandchildren's uncle. So not the grandchild's parent, but the grandchild's uncle. And it was specified in the will that those grandchildren couldn't have that money until a particular point in time. Right? So like an age threshold. Let's say for argument's sake it's age 30. Now, what people don't potentially realise is that in that scenario, the executor is not able to distribute the money outside of the estate to those children into their name until they turn 30. So the scenario that we ran through here is that parent approached us directly thinking that they could open a kids account, but you can't pay the money out of the estate. What you actually need to have is an estate account. And under an estate account, which is basically an account in the name of the deceased. So I don't know why we're pretending you're dying. I'm sorry. But
I'll be the scenario,
like it would be, let's say with Annie, it would be estate of Christine Jensen, and then basically like for the benefit of Annie, right? We couldn't legally put that money in Annie's name until we've met the threshold in which you've said she can have the money.
So when Annie turns 30.
Yes, exactly. Annie's turning 30. So we need to keep the money, or the executor needs to keep the money in the name of the estate. And if that's the case, the executor is the person that controls the estate. So the executor needs to be involved with the, what's the word? Like the guardianship of those funds and that money for the period of time until these children turn 30. Now, in that scenario, that added some complexity because the uncle was obviously a fair bit older. Well, actually, it was a great uncle because it was the uncle of the mum.
Oh, so
of the grandkids.
great uncle.
Do you know what I mean?
So
it's
the
great
like
uncle.
grandma's sibling.
Yes, exactly. The grandparent's sibling, right? Now, let's assume that they're a bit older, and also like, where are those people living? Do they want the complexity of the admin? They also want to give flexibility to the parent to appropriately choose where that money's going and the likes. They then needed to go through a ton of additional legal work to basically make sure that there were agreements and various appointments, because they essentially needed to make the parent in this instance a trustee after the fact of the will being like created and the person passing.
Yeah, right.
Yeah. And so one of those things, I guess that's just like a little technical nuance, right? Where if, you know, people might be really well intentioned leaving specific gifts or monetary gifts that can only be accessed at certain ages. But if you're doing that, you need to make sure that within the, you know, executor position or stated within the will, it's really clearly specified that, you know, for you, I'm assuming you would want your sister to be the kind of guardian of that money until such time that Annie can actually access it, because that's going to be the easiest thing to ensure that it gets to the right place.
Yeah, for sure.
So yeah.
So the moral of the story is have a bulletproof will.
Yes.
And make sure you get legal advice maybe on that.
And get them to like play out the scenarios, right? Be like, okay, so you are well intentioned and you're giving your grandchild like $20,000, like when, and okay, they're currently 3 and you want them to have it at 30. Who's going to be around in 27 years to administer that? Who is capable within your family unit of taking on that admin burden? Who's going to make good choices for them? Who has like the information and knowledge to do that? Because oftentimes, you know, in the case of estate planning, we're picking someone that's close to us or that is very wise or, you know, independent potentially, and perhaps like missing out on that aspect as well. So hopefully a good lawyer is like talking you through those scenarios. But yeah, have a really good will, make sure it's workable for the actual beneficiaries. And if you don't have a will, understand what a distribution of an estate looks like under New Zealand law. And if that's not what you want, go and get a will.
Yeah. I think after this podcast, I'm like, I will get that sorted.
Yes. And it doesn't have to be complex, you know, and I think like people, you know, you can change your wills obviously over time. But particularly if you have a individual investment account, because I know you were going to ask me about like, well, what if it's a joint investment account or what if it's a company or a trust? So if it's a joint investment account or if it's in a different type of structure like a company or a trust, it will be dealt with differently. The main thing to call out with a joint investment account, when we say joint investment, it needs to be that the investment is owned in both individuals' legal names. So you need to make sure that the account actually has, you know, like Christine and Oliver to make sure that that's the case. Same thing with, say, property, that you're both on the title. I was like, what's that word? Title. You're both on the title. And in that instance, the ownership structures for investments are what's called like joint and severally in terms of instruction, but also it is jointly owned, not tenants in common.
Tenants in common. What is it? What does that
So
mean?
tenants in common is a joint ownership structure that is sometimes used for property, which basically means we are 50-50 owners, that if one owner was removed, let's say in this instance by death, they would be replaced by someone else. And the other owner would have their portion remain the same. Whereas jointly owned is you and I own an asset together and I pass away and you now own all of the asset.
Interesting. I did not know that.
Yeah. So that's also, I guess, a nuance to call out with, say, property or potentially investments. If, I don't know, you have an investment account with a sibling, like I've seen that before, not super uncommon. If you want that investment account to not just default to that other person in terms of 100% ownership, you need to make sure that that is also specified in your will.
Yeah.
Otherwise it will default to them.
Love it.
Yeah.
Cool.
Yeah.
Nice. Anything else to add? I mean, I can just I'm playing lots of scenarios. I want to be like, oh, but what happens in this edge case? But I think it's really just a case of like, it's your personal situation. Get advice, legal advice probably.
Definitely. And thinking through, I think like, I mean, I'm the worst at saying this because we've been sitting on our wills for ages, because I think sometimes like playing out all the scenarios, you just end up second guessing and you're getting in the weeds, and then you're like trying to play out every edge case, and you're not going to be able to cover that all. Yeah. But I think just making sure that you've got the core things covered, obviously focusing on the things that are your largest assets as well, right? Like they're the things that are going to be most material to your family. One thing that's commonly overlooked is like life insurance proceeds.
You're right, yeah.
Because, you know, depending on the size of your estate, that could also be significant if you pass away earlier in life and you've got a young family and you're like well insured. So really, you know, this is why great estate planning lawyers, the first thing they're going to ask for is like, give us your balance sheet. We need to see what you've got, you know, and make sure you understand the ownership structures. And if you are in a like partnership or you have a spouse, even if you're married, like what are the ownership structures of all your cumulative assets? If there's bank accounts in one person's individual name, if there's you know, I have Luke and my investment account only in my name.
Yeah, right.
Being real clearer with that with a lawyer from the get-go will obviously therefore help what needs to be addressed in a will.
Yeah, nice.
Yeah.
Love it. Great.
Better get a will, otherwise Lily's getting all that money. So
So we've got some key
have
actions
a house
here.
and then like nothing else. We'll have 155,000.
Yeah. And then the rest is for other people.
Although actually interesting, yes, so I guess in this scenario I've got parents and I've got children, so
they'll get some.
If there's a spouse or partner and children and parents, what's that? I guess it goes mostly to the children. It would be Lily.
And then maybe what, like a third?
Yeah,
or 2/3 or something.
Yeah. Also, just real fun fact, if you were single and you didn't have any kids and you have no surviving parents, everything goes to your siblings.
Oh. I mean, that makes sense.
Yeah.
What if you're an only child?
Great question. Don't know. Lawyers that listen, please reach out. But yeah, you know, also things to think on that, right? Because people have complex family relationships.
Yes, they do. Maybe you've got some great friends that need some money.
Yeah, not everything is created equal. Family is more than the people that we're related to. So
yeah, community for the one.
Wills are relevant for everybody.
Yes, they are.
Yep.
And cool. On that note, we're going to round out there. Say big thanks to Kernel for enabling us to do what we do. Don't forget to hit like and subscribe whether you're tuning in, whether that's video on YouTube or listening on Spotify or Apple Podcasts. If you have questions, feel free to get in touch at It's No Secret on Instagram. Send us episode requests, feedback, and we'd love to hear from the loyal listeners on this chat generally. But otherwise, thanks for listening and we'll see you next week.
Bye.
Bye.